The double tap doctrine. When the war on drugs becomes a war crime. Imagine for a moment you are floating in the Caribbean Sea. Your boat has just been destroyed by an airstrike. You are injured. You are unarmed. You are treading water, trying to survive. In the history of modern warfare, this is the moment where you are considered hors de combat, out of the fight. You are no longer a target. You are a human being in distress. But according to court documents and intelligence leaks that have emerged over the last 72 hours, for the United States military operating under current Defense Secretary Pete Hegseth, this isn't the moment the shooting stops. This is the moment the second order is given. It's called a double tap. A second strike designed not to disable a vessel but to ensure there are no survivors left to testify. We are not talking about a rogue militia or a shadowy mercenary group here. We are talking about the United States Department of Defense, and we are not talking about a battlefield in a declared war zone. We are talking about drug interdiction operations just off our southern borders. This week, a federal judge didn't just issue a standard ruling, he issued what legal experts are calling a final warning to the administration. We are looking at a constitutional collision that involves the White House, the Pentagon, the federal judiciary, and now potentially the International Criminal Court. I know the headlines lately feel like a blur of outrage, and it's easy to tune out. But in this video, we are going to stop, take a breath, and actually read the court filings that most cable news segments gloss over. We are going to explain exactly what extrajudicial killing means under U.S. and international law. We're going to look at why the administration is fighting so hard to hide the video footage of these strikes. And most importantly, we're going to answer the question that hits closest to home. If the executive branch can claim absolute immunity for executing people without trial in the Caribbean, what legal protections are actually left for citizens right here in the United States? I'm Daniel Kershaw, an independent legal and political journalist. I don't work for any party, campaign, or cable network. I just follow the facts, the law, and the paper trail wherever they lead. So ask yourself this before we dive in. If the government decides that efficiency is more important than the judicial process, where does that line actually stop? Because right now that line is being drawn in blood. To understand why a federal judge is threatening contempt, and why the phrase war crimes is suddenly appearing in domestic legal briefs, we have to look at the timeline. And when you look closely at the dates, the speed of this escalation is frankly alarming. The military operation in question began in September 2025, just about 3 months ago. This was the rollout of a new, aggressive strategy by the Trump administration and Defense Secretary Pete Hegseth to combat drug trafficking. Now, let's be clear about the reality on the ground. The drug crisis is devastating. Fentanyl and narcotics trafficking are killing tens of thousands of Americans. No rational person is arguing that interdiction isn't necessary. The government has a duty to protect its borders and its citizens. That is not in dispute. But here is where the legal ground shifts beneath our feet. Historically, drug interdiction is a law enforcement activity. It involves the Coast Guard, the DEA, and arrests. Suspects are detained, evidence is seized, and trials happen. However, starting this past September, the rules of engagement changed. The administration moved from a law enforcement model to a war model, but they didn't just change the label, they apparently changed the objective. The goal shifted from stopping the drugs to eliminating the people carrying them. According to the documentation currently under review by federal courts, in just 90 days, there have been 22 separate military strikes on 23 vessels. The human cost? 87 confirmed deaths. 87 people. Now, in the context of a global war, that number might seem like a statistic. But in the context of maritime law enforcement, outside of a declared war zone, that number is staggering. These were not combatants in tanks, these were individuals on boats. And the core of this legal crisis isn't just that they died, it's how they died. The administration's public stance, echoed by Secretary Hegseth on social media, is that this is about deterrence. They argue that the old way of arrest and extradite wasn't working, but buried in the operational reports is a detail that changes this from a policy debate into a potential criminal conspiracy under international law. But the statistics are just the surface level. What happened on September 2nd and the specific tactical decisions made in the command center is what has turned this into a five-alarm fire for the rule of law. And that's what we need to break down next. Let's look at the incident that triggered this federal investigation. It occurred on September 2nd, 2025. Based on leaked intelligence summaries and the allegations currently before the court, U.S. military assets identified a vessel suspected of trafficking narcotics. They engaged the target. The initial strike did exactly what you would expect. It disabled the boat. The vessel was dead in the water. The occupants were either killed, wounded, or thrown into the sea. In a standard military or law enforcement engagement, the threat is now neutralized. The next step is usually assessment, rescue, or capture. But that didn't happen. Instead, the allegations state that a second order was given, a double tap, a follow-up strike specifically targeting the debris field and the survivors. I want you to pause and really process that. We are talking about targeting individuals who are struggling in the water, likely injured, with no means of fighting back and no means of escape. When reports of this tactic began to surface, the reaction from the White House was not denial. It wasn't a promise to investigate a rogue commander. It was a doubling down. On December 10th, former President Trump took to Truth Social. In a post that will likely become Exhibit A in future legal proceedings, he didn't just defend the policy, he attacked the oversight. He referred to the federal judge presiding over the inquiry as a fake judge. He labeled the investigation a witch hunt designed to cripple the war on drugs. This is a pattern we've seen before, but the stakes here are physically higher. By claiming that war crime statutes don't apply to his operations, the president is essentially arguing that the executive branch has the authority to redefine murder as policy, provided it attaches the label of drug trafficker to the victim first. And the administration is backing this rhetoric with obstruction. The federal court has requested video footage of these 22 strikes. This is standard evidence discovery. If the strikes were clean, if they followed the rules of engagement, that footage would exonerate the military commanders immediately. But the administration is refusing to release it. They are stonewalling Congress. They are defying judicial orders. You have to ask yourself, why hide the tape? If this is a righteous operation against dangerous cartels, wouldn't you want the world to see your success? The refusal to comply with the court suggests that the footage confirms the worst-case scenario, that these were not combat operations but executions. But while the administration might be able to stall a domestic court, they have a much bigger problem brewing across the Atlantic. Because while Trump can insult a federal judge on social media, he cannot simply tweet away the Geneva Conventions. This brings us to the why it matters portion of our analysis, and I want to get specific about the law here, because words matter. There is a concept in international humanitarian law called hors de combat. It's a French term that translates to out of the fight. Under the Geneva Conventions, which the United States has signed, ratified, and historically championed, a person is hors de combat if 1. They are in the power of an adverse party. 2. They are defenseless because of unconsciousness, shipwreck, wounds, or sickness. Or 3. They clearly express an intention to surrender. The law is absolute on this. You cannot attack someone who is hors de combat. It doesn't matter if they are a bad guy. It doesn't matter if they have drugs. It doesn't matter if they are terrorists. Once they are out of the fight, killing them is not an act of war. It is a war crime. It is murder. This is the line that separates a disciplined military from a death squad. The United Nations High Commissioner for Human Rights, Volker Turk, has not minced words. He has publicly categorized these actions as extrajudicial killings. Let's break down that term. Extrajudicial means outside the law. It means the state is bypassing the entire machinery of justice, judges, juries, evidence, defense attorneys, and jumping straight to the sentence. And the sentence is death. Look, I get it. I read the comments. I talked to people. There is a lot of frustration out there. People are tired of crime. They are tired of the drug crisis. And there is a visceral part of us that thinks, good riddance. These poison peddlers deserve it. If you feel that way, I don't blame you for being angry at the drug trade. But here is the hard truth that we have to swallow as adults in a democracy. We don't have laws to protect the saints. We have laws to control the powerful. If we establish the precedent that the government can execute people based solely on suspicion or intelligence without a trial, we are handing them a weapon that will eventually be turned inward. The situation has escalated so severely that the International Criminal Court, ICC, is reportedly opening a preliminary examination. Now, the U.S. is not a party to the Rome Statute. Historically, American presidents have argued the ICC has no jurisdiction over Americans. But here is the legal detail that the administration is ignoring. The ICC does have jurisdiction over crimes committed on the territory of its member states. Many Caribbean nations are ICC members. If a U.S. drone strikes a boat in the territorial waters of an ICC member state, the court has a hook. The Trump administration's response to this international scrutiny has been aggressive, to put it mildly. Reports indicate they are threatening sanctions against ICC judges and prosecutors. Think about the optics of that. The leader of the free world is threatening to sanction judges for investigating murder. That is the behavior of a pariah state. That is the behavior of regimes we usually impose sanctions on. If you are thinking this is just some foreign policy squabble that doesn't affect your mortgage or your job, you are missing the forest for the trees. Because the mindset that allows a president to ignore a federal judge on war crimes is the exact same mindset that allows him to ignore a federal judge on tax law, property rights, or election results. This case is not happening in a vacuum. It is the latest and perhaps most violent chapter in a story we have been watching unfold for months. We have seen this administration clash with Judge Boasberg over deportation cases. We have seen them argue in appellate courts that the president has absolute immunity from criminal prosecution for official acts. The pattern is undeniable. The executive branch is systematically testing the fences. They are pushing against every check and balance to see which ones will break. When Defense Secretary Hegseth orders these strikes, and when the president defends them by attacking the legitimacy of the court, they are asserting a theory of the unitary executive that borders on monarchy. They are saying that the president's power as commander-in-chief overrides the judiciary's power to interpret the law. From a legal perspective, this is deeply troubling. It suggests that the administration views the law not as a set of binding rules, but as an inconvenience to be maneuvered around or bullied into silence. The international fallout is already beginning. Allies who have stood by the U.S. for 70 years are watching this in horror. How does the U.S. diplomat in Geneva stand up and condemn war crimes in Ukraine or Gaza when the U.S. military is conducting double-tap strikes in the Caribbean? We are surrendering the moral high ground. We are handing our adversaries a propaganda victory that they will use for decades. You do it too, they will say. And for the first time, they might be right. But the domestic fallout is the real danger. If the administration succeeds in stonewalling this investigation, if they can hide the tapes and sanction the investigators and suffer no political consequences, then the precedent is set. The war on drugs becomes a blank check. And history tells us that emergency powers seized during a war have a nasty habit of becoming permanent fixtures of peace. This is the nightmare scenario for constitutional lawyers. It's not just about the 87 people who died. It's about the silence of the system that was supposed to prevent it. It's about a Congress that is too paralyzed to demand the footage, and a public that is too distracted to notice the erosion of their own values. If this doesn't worry you at least a little bit, I don't know what will. To wrap this up, let's be clear about what is at stake here. This is not just about Pete Hegseth playing soldier in the Caribbean. This is about the fundamental structure of American democracy. We are witnessing a stress test of the Constitution. First, the executive branch is conducting operations that fit the definition of extrajudicial killings. Second, they are claiming immunity and attacking the legitimacy of the courts that try to investigate. And third, if they win this standoff, the executive branch effectively becomes a law unto itself. When the history of this era is written, this moment might be seen as a turning point. The moment when we decided whether we are a nation of laws or a nation of men. The moment we decided whether innocent until proven guilty applies only when it's convenient or if it's a non-negotiable principle. The 87 people who died in the Caribbean, some guilty, perhaps some innocent, we'll never know, are gone. But the damage to the American legal system is still happening, right now in real time. At its core, this isn't about drugs, it's about power. It's about whether we still believe that even the President of the United States must answer to a judge. Because if the answer to that is no, then we aren't citizens anymore. We're just subjects waiting for the next order. I want to turn this over to you because this is a heavy topic. Where do you draw the line? If stopping the drug flow requires bending the law and ignoring the courts, is that a price you are willing to pay? Or do you believe that preserving the rule of law is more important than any single military victory? Let me know your thoughts in the comments below. I read them and I'm genuinely curious to see where you stand on this. If you found this analysis useful, if you value digging past the headlines and looking at the actual legal reality, please consider subscribing and hitting that notification bell. It helps us keep doing this work, independent of any campaign or corporation. I'm Daniel Kershaw. Thanks for watching and keep your eyes on the evidence. Use arrow up and arrow down to select a turn, enter to jump to it, and escape to return to the chat.